Good afternoon and welcome to Conversations with Caregivers, sponsored by the Nevada Caregivers Coalition. This is our new monthly forum for caregivers to gain information and to share their concerns with us. The coalition works to create community awareness of the amazing work of caregivers, to change public policy on issues facing caregivers and their families, and to provide information and resources through forums such as this one. I am Deanna Hearn, your host, and I'm president of the Nevada Caregivers Coalition. Founded in 2003, the Nevada Caregivers Coalition is a statewide group of organizations, agencies, businesses, and individuals who are dedicated to supporting and recognizing the efforts of caregivers who provide care to individuals and loved ones across the lifespan. Every November, in celebration of National Family Caregiving Month, we host a recognition event to honor amazing caregivers throughout Nevada. We encourage you to visit the Nevada Caregivers Coalition website at nvcaregiverscoalition.com. You will find our blog, a calendar of events each month, and how to join our monthly meetings. We also have a Facebook page and encourage you to check it out. We meet on the second Wednesday of each month from 11:30 a.m. to 1 p.m. on Zoom to discuss current issues facing caregivers throughout the state. Our next meeting will be on Wednesday, June 9th. If you're not a member, we encourage you to consider joining us. There is no cost to join. Simply send us your information on the contact form, which is available on the website. So our speaker today is Jennifer Richards, the Chief Elder and Disability Rights Attorney with the Nevada Aging and Disability Services Division. Jennifer is a native Nevadan, a graduate of the University of Nevada, Reno and Gonzaga University School of Law. Before joining the state, she worked for various legal aid organizations, providing advocacy for seniors and vulnerable adults, including extensive work defending individuals under guardianship proceedings. She has the distinction of having argued a case in front of the Nevada Supreme Court, and she serves on the Nevada Supreme Court Guardianship Commission. Jennifer will be exploring how people with disabilities or those who are aging may still be capable of making decisions about their lives. She will discuss supported decision-making, including types of advanced directives, supported decision-making agreements, and guardianship. Go ahead, Jennifer.
Thank you very much, Deanna, and thank you everyone for having me this afternoon. It's a pleasure to be with you. First, I want to say thank you for the love and support you provide to those in your families or those that you care for. That's a huge task, and I can tell you from the cases that I've had, it's very meaningful what you do. If we can pull up the slides. Thank you, Marcia. I'd like to talk a little bit today about the legal framework supporting decision-making in our state. First, my role as advocacy attorney is a governor-appointed role, and it's actually in our statutes. And the primary purpose of this role is to provide education, advocacy, and technical assistance to agencies throughout the state. I also oversee all of our legal services providers throughout Nevada as the legal assistance developer. That means I work with them to help provide free legal help to persons over 60 statewide. And finally, I also have served on the statewide Guardianship Commission for the last several years to help reform our guardianship laws to be more person-centered. I thought I would start with just outlining for everyone the United Nations Convention on the Rights of Persons with Disabilities. A lot of folks don't know that this exists, and I think it's really important to set the framework for individual rights. So there are 8 guiding principles that have been ratified through the United Nations, and that's respect for the inherent dignity, individual autonomy, including the freedom to make one's own choices on the independence of persons, the right to non-discrimination, the right to full and effective participation and inclusion in society, respecting difference and acceptance of other persons with disabilities as part of the human diversity and as humanity overall, equality of opportunity, accessibility, equality between the sexes, and respect for the evolving capacity of children with disabilities, and respect for the right of children with disabilities to preserve their identities. Next slide, thank you. And so keeping in mind that framework, that powerful statement of individual choice, of the rights of the individual, and how we consider that in our role as caregivers, and how the law plays into that. So your perspective matters when you approach a situation, and we're all biased in some way. We're shaped by our experiences. So I want to propose a couple things to help you look at those biases and look at those experiences, and then we'll discuss that under the legal context. I would note, even from that language from the United Nations, we've moved away from using the word ward. You may have heard the word ward. We don't use that word anymore. Now we use protected person or person with a disability, because over time we're focusing on the individual and away from the diagnosis or the status. Next slide. So if we think about the perspective as a caregiver, caregivers want to protect. They want to make sure somebody's safe. And so what freedoms is that person willing to give up to make sure someone's safe? Does that person even want to be protected? If you put yourself in the shoes of the individual instead of in your role as a caregiver, what would they respond? The same is true with lawyers. Historically, lawyers want people under guardianship. We want to minimize risk. We want a clear legal answer. We want control. We want confined boundaries. But is all risk bad? Aren't people entitled to have some risk in their lives? We call that dignity of risk. If I want to go skydiving, for example, that's very risky. But should we allow that level of risk? And so historically, lawyers have used guardianship as a means to minimize the risk. And we've looked at our laws in this state and asked the question, why? Why can't we allow people to make more decisions and to have some level of risk? Next slide. So with that assessment of risk and individual decisions, we really come to a consideration of how far do individual rights go and how far does personal autonomy go in our society? Is guardianship really helping people with disabilities to access service? Or is guardianship an intrusion on the private lives of these individuals? And is it used as a way to control and isolate them? Is it used as a way to place them in a living situation that they don't want? And if you've answered that question one way or the other, ask yourself why. Why do you think guardianship is helpful, or why do you think guardianship is harmful? So along with that, on the other side of things, we have what's called supported decision-making. And that's a relatively new concept. even though it's been practiced for hundreds of years. But under our laws, supported decision-making is somewhat new. And the discussion has been the same with supported decision-making. Are we empowering people to make their own decisions with the natural supports that they already have in their lives? And we're just catching up the law to recognize that? Or is supported decision-making a way for people with disabilities to be influenced without any judicial oversight? And I'd be interested in the Q&A if someone wants to share their thoughts, but do you lean more one way or the other? Do you think we should really be utilizing the guardianship system, or do you think we should be using supported decision-making? And if you are leaning one way more than the other, consider why and what experiences have helped shape that decision or that perception that you've come to. So this all boils down to the context of what we consider for individual rights based on our experiences. You know, if you've always lived at home, it might be scary to consider living somewhere else. If you've always had a guardian and now a new attorney comes in and suggests that you use supported decision-making, that might be very scary for both the individual and the family to consider, because you've never known anything besides guardianship. And if you're an older adult, you might be scared to admit that you need help because of the assumptions that others may make, that you need help, therefore you can't manage things on your own, and you need a guardian, or you need someone to take over legal control. And when you consider these things, I think we always have to also take a step back and consider our own moral compass, our own ethics. If I could share a quick example, I had a guardianship client a few years ago, and he had some physical limitations, but his capacity was not in question, yet he was under a guardianship. And some of the decisions that he wanted to make were to smoke, to drink alcohol. He wanted to go to the Mustang Ranch and have a lady friend. And he also wanted to spend money on fixing up cars and doing things like that, which his guardian disagreed with. And she felt that those were not safe activities. Those were too risky. And so she, as guardian, had decided to forbid him and prohibit him from those activities. So I would ask, in the consideration that we're talking about, she was also his caregiver. She was his guardian and his caregiver. Where was her bias in that? Where was his dignity of risk? Where were his rights? Was she acting to his benefit, or was she acting to his detriment by prohibiting him from experiencing those things? And that was a very difficult case, because on the one hand, he was safe, but he wasn't living the kind of life that he wanted. Next slide. And so that example kind of feeds into this as well. That caregiver / guardian had always done things a certain way and felt if they expanded from that, he would no longer be safe, that he needed to be protected. And I think that through the court system, it really came out that it's a balance. There's a fear there, but there has to be some level of risk and some dignity of individual rights. And when we consider things in the context of what the United Nations has stated, that gentleman had the right to drink and smoke if he wanted to, as long as it wasn't medically contraindicated, right? So whoever you're working with in your life, I think that you should step back and consider these things. Next slide. So with all of that said, now that we've kind of laid the context, really, what is supported decision making? And why has Nevada adopted it under our laws? So supported decision making is just an overarching term for what we do every day. And that's getting help, getting input from those that we trust to help us make a decision. To doing research, balancing options, and that's part of a natural network of supports. But previous to Nevada passing the law, we didn't necessarily recognize it. And why is supported decision making important? It's important because when we don't have a stake in our own lives and we don't have a say in our own decisions, the data tells us that's tied to negative health outcomes. And so supported decision making is part of the social determinants of health. So those are the things that we look for people to be healthy. And social determinants of health include lots of things: housing, obviously medical care that you're receiving, your financial stability, your network of supports. It's a holistic way of looking at the individual. And this is one tiny piece where we're assessing, do they have a voice in their own life? And we know from the data that when that voice is suppressed, that individual has negative healthcare outcomes. Next slide. Nevada's law on supportive decision-making is one of the broadest in the country, and that was intentional. And when you think of supported decision-making, you use it every day in your life. You get help thinking about pros and cons, consulting with different experts to decide what kind of care you might receive. Just this morning, I had to call IT to help me figure out how to fix my computer and decide, what software to download. So we all do this every day. We seek advice. I still call my mom for advice, or my sister, and that's all supported decision making. Next slide. But even though that's a natural function of our supports in our life, what if that was held against you? What if getting help was considered negative? And this is where we talk about ageism, because, consider in your mind the following situations. And I would first consider a 25-year-old. So a 25-year-old comes to you and wants advice on getting in a bad relationship. A 25-year-old wants to come to you about advice for missing a rent payment. Now consider a 55-year-old, and now consider a 75-year-old. So why would we penalize someone for seeking natural supports that we all utilize? It's how we've colored that aspect of society, right? And supported decision-making is saying, no, let's move away from that and recognize that as an important social determinant of health. I would add that many people are not aware that, accommodations are protected under the American with Disabilities Act. So if you need someone to go with you for your doctor's appointment, that can be covered under the ADA. And you shouldn't be penalized for exercising your right to have that assistance. Next slide. I didn't include too much on the ADA in this presentation, but if you have questions about the ADA, that's a whole separate presentation that I'm happy to discuss. But we're coming to kind of the point of this context here, which is understanding supported decision-making versus substituted decision-making. So you can see in the illustration, supported decision-making is where we're acting together. You're involving me in the decision, and then I'm ultimately making the decision with the assistance of individuals that I trust. What we've traditionally recognized under our laws is really substituted decision-making. And you can see from the graphic, that's really outsourcing the decision. I may have laid some groundwork or some roadblocks on the decision-making, but it's being outsourced. That's changing, and that's why it's important to have this conversation, because really we're trying to move towards the supported decision-making model and away from substituted decision-making models. Oh, next slide. So I wanted to stop here and take a moment to consider this in the dementia diagnosis context. And there's a great law professor, Megan Wright, who's done a lot in the legal arena on supported decision-making and dementia diagnosis. And what the data tells us is that even with that diagnosis, persons want to be actively involved in the decisions that affect their lives. But they're often marginalized, ignored, or even excluded from the decision-making process. The example she gave in one of her academic papers was a husband and wife, and the husband was right there, and the doctor and wife were making the decision without him, and he was not part of the conversation at all. And what the study outlined was that this is true even in the early stages of the diagnosis, when there are significant cognitive abilities that remain and they're more than capable of participating. And we know from our discussion earlier on that being excluded or marginalized or ignored in the decision-making process affects the social determinants of health, i.e. the well-being of that person, because they don't feel valued. They feel like a burden, they feel like an object. And so that's a really important discussion to have, is meeting people where they are based on their functional ability and not the diagnosis, and making sure that we're including them in all the decisions that they can make. And that's much easier said than done, I understand that, but looking at it holistically, that's what the data shows. And as we're going to talk about here in the next couple of slides, that's really what the law prefers and even requires now that we're moving towards the supported decision-making model. Oh, next slide. So, supported decision-making was passed in the last legislative session. It's under Nevada Revised Statute 162C. And as I kind of alluded to, we have one of the most broad statutes in the country, which means a supported decision-making agreement can really be anything. It just has to follow a couple guidelines in order for it to be valid under our laws. And that means it has to be honored. It has to be honored by medical providers, other providers across the state, and recognized. So in order for a supported decision-making agreement to be valid under Nevada law, it has to be in writing. It has to be signed by the decider and one or more supporters. It must have 2 witnesses, and those witnesses cannot be the supporters that are listed. So they need to be independent. I've typically done the supported decision-making agreement and had a notary notarize it. That's not a requirement, but I think that's the cleanest way to do it. And most importantly, the agreement has to say what the supporter can and cannot do for the person making the decisions. And importantly, it's always the individual who is making the decisions. So the supporter can help assist in those decisions, but they do not actually have unilateral authority to make any decision. So that's really the distinction as we move into a discussion about powers of attorney. So next slide. So powers of attorney. This is probably the topic that I get the most questions on from state employees, families, in guardianship court, across the board. Powers of attorney are documents that allow you to plan for incapacity. The power of attorney can be effective upon signing, or it can be effective upon incapacity, but it depends what the terms of the document say. So most people are going to have a power of attorney effective if they become incapacitated. Last legislative session, we did update the power of attorney statute to include what I call the default language. So everyone has a different way of drafting these sometimes, and it's hard to tell when they're in effect or when they're not in effect. So we went into Nevada's statute and said, if it's unclear, this is when it applies. So under NRS 162A.810, we put in if, one medical provider, I think it's a physician, APRN, physician's assistant, indicates in writing that that person's incapacitated, PO is in effect. So that's important because just because you have a power of attorney, that doesn't mean it's in effect. That person, we call them the agent or the principal, the person who's the principal, the person who's making the power of attorney, gets to direct their life and have a voice to make their own decisions for as long as they can until they're incapacitated. And we know they're incapacitated when they meet that portion I just said of the statute. A power of attorney is not a license to make all the decisions for somebody. So going back to my guardianship case that I mentioned early on, power of attorney can't say, well, he can't smoke, he can't drink, he can't have ice cream for dinner. That's usually outside of the scope of a power of attorney, right? Unless I suppose there's a specific doctor's order for medical that, you can't take this medication with alcohol. So there might be a limited exception. But on the whole, it's not a license to just take over someone's life. It's not a license to restrict visitors. It's not a license to change their phone number and redirect calls. And then the other interesting thing that comes up with powers of attorney is placement authority. So, for example, if grandpa is getting to that point where we can't provide care in the home anymore, he needs a higher level of care, and he needs to go into a long-term care setting, we need to look at his power of attorney because it may not include placement authority. And that's something that we changed last legislative session under SB 223. We updated Nevada's power of attorney statute to include a portion where the individual can indicate what type of long-term care setting they would want to live in if it came to that point. And I highly recommend that everybody update their powers of attorney to the new form. Because if you have an older form that doesn't indicate placement authority, the only way to place somebody is through a guardianship proceeding. We can't place a human being in a living situation when they cannot consent to that without judicial oversight. So that was a really important legislative change in 2019. That is free. It's in the free language for powers of attorney. If this group needs copies of those documents, I'm happy to provide them. But that is something I think that everybody should update. Also, in the last legislative session, Nevada created a specific power of attorney form for dementia. And they also created a specific power of attorney form for persons with intellectual or developmental disabilities. Again, recognizing that we're not looking just at a diagnosis, we're looking at functional ability, and the language utilized in those forms is a bit more plain language than kind of the legalese that is used in the standard documents, but they're binding and legally effective like any other power of attorney. So those are really important new tools that were added last legislative session for powers of attorney. Next slide.
So can I ask Jennifer, can I interrupt and ask who makes the determination if somebody maintains capacity or if the power of attorney should go into effect?
So that's going to be by the terms of the document, or that's going to be under NRS 162A.810, which was on the last slide. And we can talk about that more at the end through the Q&A if you have a little more specific question about that. But there has to be a writing from the medical provider, physician, physician's assistant, APRN, indicating the incapacity. And I would attach that to the document when you're providing it so that they know it's in effect. You need to present that. And I neglected to state in the last slide, if someone is living in a long-term care setting, they need to have a competency declaration attached to any power of attorney, or it's not valid. So that has to be done and attached to the document, because people in those settings are considered vulnerable under our law to exploitation. And so Nevada law has required that document to ensure they have the ability to complete it. And so the next item I'd like to mention is also fairly new, and that's the Advanced Psychiatric Directive. So this is a really powerful tool for individuals that may have mental health diagnoses. And it allows the individual to make some declarations about their preferences for psychiatric care should they need it down the line. And you know, it's a free form again. It's available on the state website. This one is only effective for 2 years. So it lives for 2 years and then it automatically expires and needs to be redone. And there's some legislative history and purpose to that. But this is a really powerful tool, especially for individuals that may have times when they're in compliance with their mental health treatment and go out of compliance. I've seen this just be really, really useful for family members that are dealing with a loved one that has mental health diagnoses. Next slide. And then we come to guardianship, which guardianship is the most restrictive option. It is considered the legal death of an individual, the civil legal death, and it does require judicial process. And so we only look to guardianship when there's no other option and all other options have been exhausted. Next slide. So a little background, what is guardianship? Guardianship is one of the oldest laws that we have. It dates back to the Roman times officially. This is a picture of the 12 tables, which if you're familiar with a little bit of Roman law history, were the original laws governing the empire. And Rome actually had a very robust guardianship system that was integrated into society. It dealt mostly with minors, of course, up to the age of 25. And you have, two types of guardians, one for the person and then a curator and a tutor. And so it evolved after that. The English adopted a guardianship system. And then, of course, the United States modeled our system after the English system. And so this is where the term parental authority comes from. It's from the Latin parens patriae, which means the state acting as a parent for a child traditionally that didn't have somebody to act for them. And it's really interesting, the Roman law, because if someone violated the rights, back then the ward, or now we say protected person, not only would they face, consequences in the civil arena, but they could also lose political rights and social standing as well. So, for example, they could lose the right to vote or participate in their communities. And it was very disgraceful if you were found to violate someone under your charge. Next slide. So I don't want to get into guardianship too much, but that's the origin of it. And, Nevada law is really moving away from guardianship because it should only be utilized when necessary. And absolutely, there are times when a guardianship is necessary. But historically, we've had plenty of times where there's been an overabundant use of guardianship, and it's not person focused. So we're really moving towards recognizing the rights of the individual, recognizing that they have a voice, and tailoring our services to their needs. And sometimes that is the more difficult route. I can tell you that in numerous guardianship cases, medical providers especially, it's just easier. Let's just ask the guardian instead of involving the person in the care conference and really getting to what they want and how they want to address the situation. But I want to leave enough time for questions. I see we have quite a few in the chat. So in conclusion, really, if you take anything away from this discussion, it's so important to access resources early and to have a plan, especially having a plan regarding your rights and your legal decision making. And I want everyone in this group to know that free legal help is available statewide. The top 3 legal services providers listed on this slide are grantees under ADSD. They provide free legal help for seniors over 60. If you need a referral, I'm happy to do so, or you can reach out to them directly, but they can help you for free to complete powers of attorney or advise you on any sort of decision-making documents that you might need. Additionally, listed on the slide is the sdmnevada.org website, which has so many great resources on supported decision-making, including sample supported decision-making agreements. And it really goes into more depth as to what supported decision-making is and the legal requirements. With that, I will be open to any questions.
So thank you so much, Jennifer. That was really an informative talk, just terrific. And you're right, we do have a number of questions in the chat, and Marcia will read them out.
Yes, I'm scrolling. I mean, you really got people thinking here, Jennifer. So hold on a second while I get to the first one. So Cheryl Donnell asks, do you do your own taxes or hire a tax preparer? Do you have someone you trust read your medical reports to help explain them? We all use trusted advisors to make decisions. And this may have been more of a comment than a question, but
Absolutely. I think that's a great comment. And it's really part of that perspective in the beginning of the presentation to think of why is that a negative thing when we're talking about someone who's aging or someone that has a certain diagnosis. And we really need to check ourselves when looking at that and consider it in the context of supported decision-making.
Great. And then Verla had another question. Moving to supportive decision-making, does that negate powers of attorney?
No. And in fact, I've done both for clients that I've served. I've done both the supportive decision-making agreement and a power of attorney, just as a best practice for my preference. If we think of it on a spectrum, if we're going from least restrictive to most restrictive, we would have supported decision-making first, then powers of attorney, and then guardianship, right, at the end. So these are tools you can use together separately. I would recommend using both the supported decision-making agreement and a power of attorney.
Great. And then Verla has another question. Is capacity considered when moving towards supported decision-making models?
I'm not sure what you're trying to ask, Verla, but capacity is always important. I'm assuming you're meaning in the medical context of capacity, not a legal determination regarding capacity, because from the legal side of things, we presume capacity. We presume people have capacity unless and until a judge determines that they don't. So we're giving people the benefit that they have capacity. I think that gets lost because one medical provider may say this or that. And we also have to remember that capacity can be a moving target. Some people are better in the morning or in the afternoon, or if they've had, this medication at this time, that may make them a little foggy. And it's really looking at the individual and making it a very individualized assessment. So I would always start with supported decision-making, and then if the power of attorney was to be completed, if they're living in a long-term care setting, capacity does play a role in that. There has to be a letter attached that they have the capacity to execute that document. But if they're living independently in the community, we presume capacity.
So I think you may have answered her adjunct question, which is legally, who makes the decision if someone still maintains capacity?
Yes, because I asked that one out loud.
Yeah.
Mm-hmm.
Okay, then Barbara Singer is asking, can power of attorney include placement authority?
a great question, and we looked at that in 2019. So when I was working before I became an attorney with the state, I noticed that we had a lot of issues with families and their loved ones needing higher level of care. And some facilities would say, yep, you have a power of attorney, sign them in. And some facilities would say, whoa, 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 your power of attorney doesn't say anything about signing grandma into this long-term care setting. And so I worked with some of our stakeholders, and we drafted a law to update our power of attorney statute to include that explicitly in our power of attorney statute. Because really, if it's not clearly stated, you may not know that you're giving someone that authority. And if it's not clearly stated legally, I question if you're giving someone that authority. So now you can go on the website, you can access the new power of attorney form, and it will have a section for placement options. And you can indicate to everybody in that document what your preferences are. And that should resolve those issues. And hopefully that will resolve unnecessary guardianship petitions. I had a case with a husband and wife. The husband had a petition for guardianship to place his wife in a long-term care setting. And it was a very difficult thing. And had they just had that power of attorney form, right, he could have saved all of that heartache, that stress, going to court multiple times, hiring a lawyer and paying them to draft all those documents. And we said in 2019, when we were making this law, this needs to be available for everybody, not just someone who can afford a lawyer to draft up everything all clear. This needs to be free and easy for everybody to use. And so now it is.
Great. So Jennifer, we had one last question in the chat from Julie. She says, when exactly did the laws change in 2019? Julie, you might want to clarify that. Do you mean when were they enacted? Julie, you can unmute yourself and elaborate. Yes, she says. So when were they enacted, Jennifer?
I will have to go back and look at the bill. It would have either been immediately upon passage, or they usually do it either immediately or in that July. Sometimes they do it in December. So I forget what month it is off the top of my head. I can get back to you, Julie, but the point is it's now been, what, 3 years it's been on the books. And still a lot of people don't know about it. So I would make sure to go access that, and I can send this group the form if it's needed. I would also add that you can register your documents with the Secretary of State for free through the Lockbox program. So you can upload them to that database. So if you end up being hospitalized anywhere in the state, on vacation to Vegas, and something happens, they're going to be able to log in and say, oh yeah, your daughter's your power of attorney. She wants to know what your medical status is, and now we can answer it because you've given her authorization to receive your private medical information.
That's really cool.
I can provide the lockbox information to this group following the presentation as well.
That would be great, Jennifer. We can send that out with our follow-up email. And we had one other question. Where do you get the specific power of attorney forms for dementia?
Sure. So all of these are provided for in statute under the NRS. They're all right there for free for everybody to use in their official form.
So online, they can download them from a website?
What I will do is I'll send you guys the PDFs.
Okay.
Yeah.
Great.
They can be a little tricky to find, I think.
Okay, well, that's the last of the questions in our chat. Did anyone have any last burning questions you'd like to ask Jennifer before we end her presentation? Okay, looks like we're all done with questions, Deanna.
Actually,
We have
Jennifer, do you mind sharing your email one more time?
Oh, not at all. It's jrichards@abse.nv.gov. I welcome anyone to email me with any questions, or if there's any follow-up from this presentation or some other matter. I'm here to provide education to the community. So I'm happy to hear from this group, other groups, and individuals as needed. And I really just want to say thank you again for having me this afternoon.
Thank you, Jennifer. This is Verla Niebuhr, and why I asked for that is I work at Cleveland Clinic, Lou Ruvo Center for Brain Health in Las Vegas, and we do a weekly lunch and learn program. And I know that we kind of want to address some of the new, the changes to the law, and we're really pushing for some powers of attorney, to encourage people to get their paperwork in line and in order. And like you had mentioned earlier, it's important to redo them because things have changed. So that's why I asked. So no, I'm not going to be emailing you every other minute.
No, please, you can.
Thank you.
So Jennifer, thank you so much. Do you have any last thoughts before we move on, since we're running out of time?
I mean, last thoughts, I would really just, again, it's not a topic that everyone wants to discuss. It's hard to think about sometimes, but it's so important to have a plan to address these issues early on. I can't tell you how many cases I've had where everyone says, yeah, we saw that coming. We knew something was coming down the road. And it's been difficult situations where a little planning on the front end could have made a huge difference for everyone involved. So have those conversations early, have those conversations often. There's free help to complete these documents. There's free resources throughout our state. If you have questions, and it's just so important to have those done.
Jennifer, this is Cheryl. Now, quick last question. Power of attorneys go to one individual, right? So you can have multiple power of attorneys for different activities, but for placement decisions, etc., you're identifying one person, correct?
You can name, technically you can name more than one agent. I would discourage that. I would name one agent and one alternate. And the placement authority is just in the healthcare power of attorney. It's not in the financial power of attorney. So you could have one person for financial and one person for health, and then an alternate in case that primary person doesn't want to serve or is unable to serve. But it really becomes problematic when you're listing all 4 kids as your agent, because then all 4 of them can make a decision together, or they can make a decision separate, and it's really a recipe for disaster. So really, it's important to name one person and the alternate.
Thank you so much, Jennifer. This is really, really helpful and important information for so many folks. We appreciate you coming today. I would also like to thank Marcia O'Malley with Mindful Media Services for her technical services for our meeting today. We have a really great committee working together to plan all of these upcoming conversations with caregivers. They include Cheryl Donnell with the Nevada Lifespan Respite Care Coalition and Nevada Aging and Disability Services Division, Riley Franco with AARP, and Mary Liverati, who is often your host for this event. We're really pleased to announce our next Conversations with Caregivers will be June 21st at 1 o'clock In celebration of Alzheimer's and Brain Health Month, we will have a speaker from the Alzheimer's Association to present Dementia Conversations. It will include tips and strategies for difficult conversations about changes in a loved one that may be related to dementia, talking to the doctor, and a discussion about medications. So Conversations with Caregivers takes place on the third Monday of every month at 1 p.m. So mark your calendars. We record all of the events and make the recording available to the public on our website shortly after the live presentation. Everyone here today will receive a follow-up email with the information to access the recording and details about our next Conversations with Caregivers forum. Thank you all for your attendance today. We look forward to seeing you in June. Goodbye, everybody. See you next month.